Hey guys, I'm Harlan Webster, and I am an attorney here in Oxford, Mississippi. I've been practicing almost 15 years doing 100% civil litigations. I've been asked to talk to you guys about various motions that are filed in civil practice. So I'm going to try to give you a brief overview and maybe a few more practical pointers on motions in civil practice. I know you have your book material in front of you, and that will give you a good detailed kind of outline, but I'm going to give you more of a real world approach or examples of how these motions are used in civil litigation. Now, every civil case is going to be initiated by the filing of a complaint. That's the lawsuit, so to speak. And in that complaint, it's going to outline the plaintiff's allegations. So motion practice is going to be anything that asks the court to make some sort of ruling based on the pleadings or based on the conduct that has occurred in the case. So that's going to be really divided in three different parts, as your book shows: your pretrial motions, your discovery motions, and then your post-trial motions. And so I'll talk a little bit about when the complaint is filed. Usually what will happen is you'll get a motion to dismiss, and that's the first motion that is filed. And in most cases, it's not going to be filed in your car wreck cases or some of your more run-of-the-mill negligent type cases, because that's just really a factual dispute. But any case that is involving documents, statutes, various laws, or how to interpret those laws, you're going to get motions saying essentially that the plaintiff did not plead adequately that the defendant did anything wrong according to the contract or the laws or statutes. So the motion to dismiss is going to be attacking the legal basis of the claim. Many times it'll attack jurisdiction, just saying this court is not the proper court for this dispute. Sometimes it'll attack service. That's very rare. Most people know how to serve process properly. You don't get that much at all. Sometimes your pretrial motions to dismiss will attack venue, saying, well, this isn't the proper county, or this isn't the proper district for this complaint. Well, the simple remedy there is to just transfer the case to the proper venue. So the case won't get dismissed. It'll just get transferred from, say, Lafayette County to Lee County, where it's supposed to be. Oftentimes, motions to dismiss, if they're not just outright denied by the court, the plaintiff can file a motion to amend the complaint. And that's simply a motion saying, well, I might not have said everything right the first time. Let me fix it. Let me fix the defects that are outlined in the motion to dismiss. And a court will typically freely grant a motion to amend a complaint. And then the case will just start over from that amended complaint. A lot of times, most times, your pretrial motions can be cured, and they won't have a huge impact on the case. Now, you'll typically get motions dismissed in like Mississippi Tort Claims Act case, Fair Labor Standards Act case, contracts, labor, employment, those sort of things that I mentioned earlier. Now, after the case, you have a complaint or an amended complaint or a second or third amended complaint, the case will proceed to discovery, and that's where each side gets to engage in litigation to find out facts, to take depositions. That's just like an oral examination of people, just like you'd see at trial, except you're just in a boardroom or a conference room taking testimony that's transcribed. You can send written questions, interrogatories, or requests for production, that sort of thing in discovery. And the other side has to answer those questions within a certain amount of time. It's usually 30 days. Oftentimes, especially when, depending on what the case is about and how contentious it is, the other side will not answer the questions properly or will be evasive. That's when you'll have to file a motion to compel. And that's where you ask the court to compel the other side to do certain things, answer properly, amend their answer, go actually do the work to find out the answer. And the courts generally don't like to have to engage in this type of babysitting of the parties, but if it's necessary to your case, then you have to file a motion to compel. The other side can get sanctioned, or there can be different repercussions for not properly doing the discovery that's required. Other motions could be like for a motion for a protective order, and that's where typically a third party will ask the court for, as it says, a protective order, saying, please protect me from what this subpoena is requiring me to do or asking me to do. It's asking for confidential or privileged information. It's undue burden. It's going to be expensive for me to go obtain these documents. It's harassing me. It's asking me for personal matters that don't have anything to do with this case. And the court will typically take that motion up and rule on that pretty promptly to either protect the third party or to tell the third party, no, you have to comply with the subpoena or the request or whatever it may be. Another motion is motion to strike. Sometimes that's just basically to throw out information that may be untimely or may have nothing to do with the case. You would file that with the court either during discovery or after the discovery deadline. And then at the end of discovery, you're typically going to get your Daubert motions, your motions that are basically attacking the qualifications of an expert witness. And the court will also decide whether the expert's allowed to testify or not. Prior to trial, you're going to get a motion for summary judgment. That's where the defense is going to file, and the plaintiff can file a cross motion or their own motion for summary judgment, because typically the defendant says, look, we've gone throughout this whole process of civil litigation. We've had the complaint, we've had all the discovery, we've exchanged documents, we've taken testimony, and even if what the plaintiff says is true, the plaintiff cannot prove its case. And essentially we're asking the judge to throw the case out right now. That's rare, but it happens. It's probably happens more often than a motion to dismiss the complaint, for sure, because if the motion to dismiss the complaint stage, you don't really know much, so you let the parties go on. But after the summary judgment stage, it's all laid out pretty clear for the court, and the court will decide, well, no reasonable juror can find in favor of the plaintiff. Conversely, the plaintiff may want to narrow down some claims and say, look, we've absolutely proven these claims, no doubt. We don't need to waste everybody's time proving up these elements because we've already done it. The defendant has no defense, and so we want to go ahead and get a partial summary judgment or something like that on our case. That's very, very rare, but it does happen sometimes. After there's a verdict, there's usually the judgment, a motion for judgment as a matter of law. This happens sometimes. This is when basically the defendant or the plaintiff, whoever is the losing party, says there's no possible way the jury could have come to this conclusion. And the judge, believe it or not, will grant this from time to time, because the judge may have been hoping that the jury would have found in favor of one side or the other, because that's just how the overwhelming facts were. The jury does the complete opposite, and then the judge has the ability to basically veto that verdict and issue a new trial or grant summary judgment at that stage and end the case altogether. A new trial is pretty rare. I see Rule 59 in your book. That's usually where there's some sort of defect in the proceedings that no one was aware of at the time. I mean, a certain jury instruction got granted, or certain evidence was granted or deemed admissible. The jury heard it, and then later on, hindsight, the court figures out, well, that probably should not have done that. I think that had undue weight with the jury, and I'll grant a new trial. What else? The Rule 60, the relief from an order. This does happen a fair amount of time in different circumstances, where new evidence is found after the fact that relieves the party of the obligation. There may be even something like a default judgment gets granted, and the party never even answered the complaint, and they got a judgment against them. It's on the books, and then you find out, well, that person was not even the right person to be sued in the first place. So it would be unjust to have a judgment against somebody who did not even take out the loan and not pay it, or didn't have the credit card and that defaulted or something like that. But that will happen sometimes. That probably happens more often than a Rule 59 motion does, but it can happen. Those are the various type of motions, or the main kind of some of the practical ways it works in civil litigation, and the anything else is going to be taken up on appeal at that point. So there you have it.